So welcome back. Finally, I want to talk to you a little bit about some case studies which are intended to help you think through how the legislation that creates the internal market interacts with the case law and the litigation that creates the internal market, and how this works out in practice. You'll need to draw on these kinds of interactions both when you're answering problem questions, but especially when you're writing essays. So here's one example about resale at a loss. The Unfair Commercial Practices Directive prohibits unfair business-to-consumer commercial practices. The directive approximates the laws of the member states on unfair commercial practices, including unfair advertising, which directly harm consumers' economic interests and thereby indirectly harm the economic interests of legitimate competitors. The directive doesn't affect national laws on unfair commercial practices which only harm competitors' economic interests or which relate to a transaction between traders. Taking full account of the principle of subsidiarity, the member states will be able to continue to regulate those kinds of practices if they choose to do so, and they'll be in conformity with EU law if they do. So Belgian law prohibited the practice of resale at a loss. And the question arose as to whether that fell within the scope of the directive. And the Court of Justice held, yes, it did, but only insofar as that provision of national law was pursued to protect consumers. Otherwise, if the provision of the national law was to protect other businesses, then it fell outside of the scope and within national competence. This was confirmed and elaborated in the VTB-VAB case. The court held that the directive is intended to establish uniform rules on unfair business-to-consumer commercial practices in order to contribute to the proper functioning of the internal market and to achieve a high level of consumer protection. See paragraph 51 of the judgment. Thus, the directive fully harmonises those rules at the EU level, according to paragraph 52. So this directive occupies the field, and member states may not adopt higher standards. What about if it's a minimum harmonisation directive, though, not a field-occupying one? This is illustrated in the case of the EU's legislation on marketing authorisation for medicines. So Directive 65/65 and a whole bunch of successor directives, known as the Community Code, prohibit marketing of unauthorised medicines in the EU. Authorisation happens in general, except for some medicines like in biotechnology, at the national level. But medicines have to be authorised at the national level if they are to be sold in the EU. But this is a rule of minimum harmonisation, and member states can therefore set higher standards applicable to their domestic producers of pharmaceuticals if they wish. But they can only set those higher standards as long as those standards are compliant with Article 34 TFEU. And this is illustrated in the Doc Morris case, which involved a challenge to a national rule which inhibited cross-border trade in pharmaceuticals from an internet pharmacy. And you'll be looking more at the Doc Morris case in your workshop. But even if there's scope for national legislation, it's often found to breach Article 34 TFEU because of that very wide definition that we looked at before of that provision and the very narrow approach adopted by the Court of Justice to the question of justification. In general, and you'll see this when you look at the case law on permitted exceptions or mandatory requirements in the words of the Cassis case, the court is very strict in terms of what it accepts as a reasonable reason for domestic law that falls within the scope of Article 34 TFEU. The measure has to be necessary to achieve the aim that the member state identifies, and it has to be suitable and proportionate to that aim. If another, less trade restrictive approach could be taken, the court finds that the measure is in breach. The court is very attuned to possible reasonable reasons that are actually reasonable only in name and are really, in fact, for trade protection. This is an example, however, where the court found that the national measure was justified. Regulation 1308 to 2013 establishes a common Organisation of the Markets in Agricultural Products. The Alcohol Minimum Pricing Scotland Act provides for the imposition of a minimum price per unit of alcohol, which has to be observed by the holder of anybody who has a licence required for retail selling of alcoholic drinks in Scotland. So the Act imposes a minimum price per unit for retail selling of alcoholic drinks, is liable to undermine the single market regulation in that such a measure is incompatible with the principle that's the foundation of that regulation, the free formation of selling prices of agricultural products on the basis of fair competition. But it was held that the establishment of this common market doesn't prevent member states from applying national rules intended to attain an objective relating to a general interest other than those covered by the common organisation of the market, even if those rules are liable to have an effect on the functioning of the common market in the sector. That being the case, the court may rely on the objective of the protection of human life and health in order to justify a measure, like the measure at issue in the case, which undermines the system on which the single common organisation of the market regulation is founded, of free formation of prices in conditions of effective competition. The fact that the legislation at issue in the main proceedings prevents the lower cost price of imported products being reflected in the selling price to the consumer means by itself that that legislation is capable of hindering the access to the UK market of alcoholic drinks that are lawfully marketed in member states other than the UK, and constitutes therefore a measure having equivalent effect to a quantitative restriction within the meaning of Article 34 TFEU. So there is a hindrance there, but the hindrance is justified on the breach of the grounds of public health. And in this context, there was clear and very specific evidence provided by the Scottish Government necessary to meet the proportionality test about why that precise minimum price per unit would meet the public health objectives, and what it was about the Scottish situation that meant that that particular type of restrictive measure needed to be introduced in order to protect the health of people in Scotland. But as I say, that's a very unusual example. Mostly the European Court of Justice is very strict in terms of applying the proportionality principle when it's looking at whether measures are justified. So bringing this all together, you need to think about how Article 34 works. It has a very, very broad scope, and the scope is drawn broadly by the Court of Justice's interpretation of very, very few words in the treaty. The broad scope is restricted only in terms of the rule in KEC for some rules relating to selling arrangements. There's no de minimis aspect to it, and it applies to potential and indirect effects on trade, as well as direct and actual effects on trade. And it catches both directly discriminatory measures and also measures that have the effect of discriminating against imported products. So you need to think about that aspect of how Article 34 works, the very, very broad scope. But then you need to bear in mind that Article 34, rules that are caught by Article 34 can nonetheless be justified either by the grounds set out in Article 36 or by an open list of grounds, reasonable reasons, mandatory requirements that the Court of Justice starts to establish in Cassis de Dijon and has continued to establish ever since. And then you need to think about here the kind of added broader dimension in terms of the role of the Court of Justice in pursuing integration, and how the court's role interfaces with the powers of the EU's legislature under Article 114 TFEU. And where the European Union has adopted legislation, there is still scope for domestic regulation, but that domestic regulation has to be compliant with Article 34. And of course, this links to some of the things that we talked about earlier in the module. So the distance or the democratic deficit arguments about how EU law about access to the internal market can be seen to be undermining domestically, constitutionally settled principles or values or cultural values or things that are better dealt with at a national level. Another critique of this has to do with social Europe and how the way that Article 34 could potentially undermine aspects of the welfare settlement. And we see that in some of the cases involving healthcare products, for instance, like the Care-Optica case. And you will remember the notion that we talked about in Fritz Sharp's work and the work of others, that free trade is a value that's constitutionally encoded in the EU. And one of the ways, or one of the places, or the sites for this constitutional encoding is Article 34. So you need to make some links between this and some of the earlier work that you did. But then you need to start thinking about, well, how might you critique this critique? Because there are spaces within internal market law for cultural or social measures to be adopted or respected or protected. And finally, I just want to say, any problems or puzzles or questions with this, do get in touch. We've gone through quite a lot of material quite quickly here. It'll take you a bit of time to disentangle it with the textbook, but please don't hesitate. If there's anything else we can do to help, just get in touch with any of us, and I look forward to hearing from you and seeing you soon. Thank you very much.